And this would be, it's not the repeal of the Indian Act, and it's not even an amendment to the Indian Act. It would be supplementary legislation that would create a property rights regime outside the Indian Act. And any First Nation that wished and could qualify, I think there's going to have to be some standards for entering it, could opt into this regime. You know, they'd have to have a referendum, make the choice collectively. What the new Property Ownership Act would do would be, first of all, to transfer the ownership of the reserves that the First Nation has to them as a community. For the first time, they would actually own their own land under Canadian law. They would no longer be tenants of the Crown. It would be sort of like, in that respect, kind of like a Hutterite colony. They would actually own their own land. And that means they could make a decisions about leasing it or selling it, whatever, you know, but they would be their own decisions they could make through their own management process. And then secondly, the legislation would allow First Nations who wanted to create individual titles on their land. All this is optional. No, under the Act, no First Nation would be forced to opt in. It would only be for those who wanted to. And secondly, once they opt in, no one would be forced to make a transition to private property. Again, this would be the will of the community. Interestingly, we have already an example of this in action, and that's the Nisga'a community on the west coast of British Columbia. The Nisga'a are one of the few First Nations who actually own their own land collectively, because they signed a modern-day land claims agreement. They are already outside the Indian Act with respect to land. And their modern treaty gives them the right to create private property if they wish. So they have, their local government has passed an ordinance creating 400 one-acre lots. And they aren't effective yet because they have to be surveyed and so on. But these are residential lots. These are for people who are already living there. They will get title to their land. And from that point on, they can, you know, maybe a couple of years from now, if you want a vacation property in the Nass Valley, you can go up there and see if anybody wants to sell. They will be able to use it as security for loans. I'm told that actually that's where the pressure for this comes from, is from members of the band who would like to be able to go to the bank and borrow to get a better fishing boat or a better logging truck, something like that. So that's an example in action, which is possible because of the particular circumstances of their treaty. So what we're proposing is legislation that would allow other First Nations to do this without having to reinvent it each time. So create a template that you can follow or apply. So, as I said, I'm not the sole author of this book. There's two co-authors, and then there's another collaborator who, his name is Manny Jules. He's former chief of the Kamloops Band, and he's now chairman of a body that you probably never heard of called the First Nations Tax Commission. This body was originally established in the late 80s to try and encourage First Nations to start levying property tax. And there are now about 130 First Nations who have some form of local taxation. So Manny's the chairman of that. He's a great believer in private property rights. His father before him and he are both real estate developers on the Kamloops Reserve. He knows this from first-hand experience. And he thinks the time has come to bring the advantages of private property to First Nations. So Manny has an order in council appointment as chairman of this commission. That means that he's not a free agent. He reports to the Minister of Indian Affairs, Chuck Strahl.